So earlier today, I had a conversation after a comment that I made online. This very nice gentleman who works for a very large defense firm uh, had said that he had picked up an insurance policy from a company and gotten a very good deal where his price went lower. So it meant that this was probably in Florida. And so this gentleman was very happy because it had the reforms were working. Okay, reforms were working. So I responded to him. Now, first of all, you have to remember that the reforms that are working, okay, as have been explained, is, you know, the like Doug Quinn of the APA recently said,
ability to recover their money if they had to sue their insurance company and one found to have been legitimately harmed. Then, and only then, did the new insurance commissioner come out and make this statement. Litigation was never the sole reason for Floridians' sky-high insurance premiums. Was never the reason. I can point to every talking head on the insurance side and show you a quote of them repeating over and over. It's litigation and it's fraud. That's what's driving it. All these companies are going under because of litigation and fraud. Greedy attorneys, PAs, crooked contractors, roof scammers. That's what's happening. The state went 12 years without a storm until 2017, a period in which insurers were enormously profitable. Many went out of business anyway, with regulators routinely blaming mismanagement and fraud by the insurers for the failures. Litigation has not been cited as the cause of a single insurer failure. Of course, this came out after it was too late, after the damage was done. But this party's coming to your state soon.
that you know the head of the Office of Insurance Regulation that in Florida basically said that no, he basically gave very clear statement that the folks that always go with the reason why insurance rates are so high in Florida is because of litigation cost. And that guy said, nope, that never has been a reason for any insurance carrier in Florida to go out of business. And that is starkly different than what has been said over and over and over and over and over in industry rags, on national TV, on just the getting into the ether that all of these problems are because of litigation. Like I have that in my head. So when I'm writing this to this guy and I say, great, you got a policy, but it's probably got right to repair. It's got an appraisal clause that says if you and we agree to go to appraisal, it doesn't say it promptly pays anything. It has a 10K water loss cap. He also didn't say that it ACV'd his roof. That was if it was over 10 years old. He didn't say lots of things, and he didn't mention the fact that those folks probably don't have to pay that claim very time, because the only remedy under the law would be that they would get an attorney if they weren't remunerated properly. But now they would only be able to do that if they had a claim that was worth something, because nobody's going to take something that doesn't have enough money in it. So the poorest among us and the smallest claims among us don't really have any representation at all. And he just said, he responded and says, sounds like you just want your plaintiff attorney buddies to get fee shifting. That's not actually what I said. What I did happen to think about, though, was let's talk about the notion of fee shifting. Okay. Now, if somebody does, like an insured doesn't pay for an umpire bill that I send out, I'm going to ultimately sue them. When I sue them, they're going to pay the legal fees. They're going to pay for my attorney. They're going to pay for legal fees. They're going to pay for collection costs and all that good stuff. They're going to pay that. They don't call that fee shifting. They call that normal course of business. So basically, in pretty much everything else on the planet, if you are the loser, you get to pay the bill for the opposing counsel. but not when it's the insurance carrier. And to say that, like it's some kind of sinister thing to imagine that having a contract of insurance and a contract of any other sort work the same way is not crazy. Do I think that there's nobody in the game that abuses that privilege? Really? No. Do I think that? No. Sure people abuse it. But there's abusive people in all areas of business, and small abuses don't equal throwing the baby out with the bathwater. And I would also say, recently I was at a trial that ruled for the defense. It ruled for the defense because when the carrier's adjuster had originally seen the property, he had asked the insured, "Is there any damage inside?" And the insured said, "I don't live here. I just got here. I didn't see anything. But like I said, I don't live here and I haven't been here very long. I just came to meet you." And the guy finished his exterior inspection, got in his car and drove away. And in trial, the carrier said that the insured did not allow the interior inspection of the property. And therefore, the insured lost $167,000 in reasonable and appropriate coverage. That was abusive because, see, that wasn't true. Because everybody who's ever been trained as an adjuster knows that if you weren't going to go in the house, you'd have to get some kind of waiver from the insured. Everybody knows it, except for the people in the jury. So when we talk about abuses, we can talk about the abuses of everybody, but we don't throw the defense attorneys out because they take on a vigorous defense of their client that happened to, in this case, recoloring something into wrong on the part of the insured that wasn't wrong at all. We don't call that poor behavior. We don't call that unethical behavior, but we call fee shifting evil because it's like every other contract on the planet. So all these reforms are working really well for insurance. And I would agree with you. These reforms are really working well for allowing some folks to operate in a way that is not reasonable or appropriate for the way to have a contract and then provide services. We wouldn't let contractors do that. We don't let PAs do that. We don't let IAs do that. We don't let anybody do that. But if we say that that doesn't seem like it's fair and it doesn't seem like it's right, then it suddenly means that I'm beholden to the plaintiff when I'm not at all. Matter of fact, I'm about to send out an award that's going to literally crush the insured side of the coin on this. I don't feel bad about it because it's right. Because I'm not for one side or the other. What I'm actually for is fair dealing always. But I think that we have gotten this ultimate comfort in taking facts and just recoloring them into something they aren't in this industry. And it's just not that hard to figure out what is. It's just not. Peace, Sean. Have a great weekend.